distortion of competition refers to effects in the market that disadvantage private operators. And at 59, I break that down into three components. First, the non-taxation. Second, would, in brackets not might, lead to effect in the market. Third, that would disadvantage private operators. I believe I've already made good, or tried to make good, the first proposition that it's the non-taxation which must cause the effects, not something else to do with the position of the party. And that was by reference to the tax sat origin case, which I showed you very early on today, paragraph 58. My second proposition also can be seen in the tax sat origin case, as I referred to earlier. Paragraph 59, which I showed you earlier, I'm happy to show it again, but if I've already shown you, I'll presume you don't want to see it again, where the court said, as the Advocate General has stressed, if irrespective of any taxation or exemption, the groups are assured of keeping their members' custom, there is no reason to take the view that its exemption closes the market to independent operators. So that's the starting point, is that we can see the Court of Justice there looking for an effect in the market when it's assessing distortion of competition. And I say that's supported by the principles applied in relation to TFEU Article 101. As this court will know, that article prohibits inter alia, subject to exceptions, agreements between undertakings that have the effect of preventing, restricting, or distorting competition. And in the network rail infrastructure case, which my lady Justice Asplin will be very familiar with, there's a helpful statement of principles that are applied in that context. And if I may just show you two of them, they are set out in my supplemental skeleton, but in my submission, they're very important to how we look at the Upper Tribunal decision here.
For which proposition? About potential competition?
No, not potential competition. So I accept potential competition must be taken into account.
Yeah.
It's two propositions. The first is it must be demonstrated that there would be an effect in the market. And if I could just show you the propositions.
Is that in dispute? I would rather doubt it.
When we come to the Upper Tribunal decision, we will see, and the FTT decision, in fact, that they both proceed on the basis that higher profit of itself gives rise to a distortion of competition without considering what might happen in the market as a result of it. So I understand that it might be in dispute. And the second point is, I'll show you them, and my lord and my ladies may well say, well, we know that. And my lady certainly does know that. She wrote it. 484, sorry, that's my reference, I think, actually.
But in competition law, there are hundreds upon hundreds upon hundreds of cases which say that. So the only question is not whether competition law says that, it's whether tax law is in some way different when the expression significant distortion of competition is being referred to.
Yes. In my submission...
Probably thousands, not hundreds.
Well, then I'm certainly... it doesn't sound like I need to show you at all. And in terms of the question whether it's the same approach, in my submission, that's just simply the meaning of distortion of competition. I can't understand a definition of that term that doesn't involve effects.
Well, the concept of competition in the TFEU is the same in. It comes from the basic concept of competition under old traditional EU law, as applied whether in antitrust law, whether in tax law, whether in law relating to quantitative restrictions on goods. Competition meant effectively the same thing. It doesn't have multiple meanings under the treaty. So since this comes from the treaty,
Yes.
you'd have thought that the concept of competition was treated as
Yes.
the same throughout.
Yes. Yes. Well, my lord knows far more about that area than I do, but I would agree.
Anyway, I'm not the advocate. I'm not being paid.
No.
So I'm just.
Well, I hope you are being paid. If there's something we should know here. But in any event, can I put you out of your misery and ask you to take us to Achilles?
I think that's a very sensible.
It's page 482, my lady. But yes, they all have a common root in the European Union treaties. So it's surprising if distortion of competition is so different depending on where you're looking.
I mean, I suppose the point is you could have an ameliorated concept of competition because of the concept of fiscal neutrality, which is intended to create some sort of a specific neutrality as between people who are subject to tax, which can have an impact on competition. So I suppose that would be where, if there was a difference, it might apply.
Because as we know from Isle of Wight, we're not assessing this in relation to specific local markets. We assess this at the national level. Whereas my understanding is in competition law, you spend some time working out
what the relevant geographic market is. It may be national, it may be regional.
Exactly. So that to that extent, there's a difference, which is derived from the fact that this is fiscal neutrality. We don't want the same goods being taxed differently in the same member state. So to that extent, there is a difference. But my submission is that when you get into the question of having said, well, it's the national market, how you decide whether there's a distortion of competition, it's the same principles, and it's the principles 95.2 and 95.4 that I particularly rely on, please.
Attention please, attention please. This is the Incident Control Officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers.
Mr. Firth, it seems that we have a natural pause. So, unless this is a counter.
Attention please, attention please. This is the Incident Control Officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated